Welcome back to Courtroom Chronicles, where real cases meet real drama. Today, we've got two defendants, two very different situations, and one judge holding it all together. First up, a young man charged with organized criminal activity, but instead of arguing evidence, he's arguing with his own lawyer. And later, a convicted felon faces another weapons charge, but this time, he's out of second chances. This courtroom isn't just about justice, it's about tension, frustration, and the raw reality of defendants who can't seem to stay on the right side of the law. Let's dive in.
Zane Bureau, that's you? 25 CR 198. You were charged with first-degree felony engaging in organized criminal activity, and Mr. Duster is your attorney. What are we going to do on this? Where are we headed? Is this going to be disposed of, or are you going to try?
I don't know what to do, honestly. I haven't been well counseled by Mr. Duke.
How do you know that?
Because he doesn't want to do.
He's not counseling you.
He's not giving me nothing besides vague talk. It's nothing.
That's what lawyers trying to do. You have to make up your decisions. They give you what the options are, and what the strengths and weaknesses of the case seem to be after discovery.
I'm not getting any of that.
And you just interrupted me. I can understand why he's having a problem with you, maybe. That's kind of rude. Both of us can't speak at once. We learned that in first grade. All right.
He's rejecting the state's offer, asking to be set on trial like that. I've asked the court to.
You're not able to hire somebody, are you? You're an indigent, right?
Yes, sir.
Okay. Has he filled out the indigent thing? Do you remember filling out an indigent form showing what you're?
Yes, sir.
It's not in this file.
Conviction probated. Yes. Okay. We got to call back there. We did.
The last time you had an income was what? What was your income?
It just varies.
What do you do? What's your profession or your occupation?
Recording engineer.
Sir?
I work in a studio, a recording studio.
Recording studio. Are you good at it? Okay, it shows like this states your take-home pay was $2,000 a month back then. Right now, you have no income. Isn't that right?
I've been in jail.
Or when you're in jail, you. All right. Status is we're still declared indigent, and so an attorney will be appointed to represent you. And your attorney here has been appointed, has been unable to resolve it without a trial. We're going to just set it for a trial. And Mr. Dusler is a competent lawyer. He can certainly do a good job. Are you asking the court for me to relieve him and appoint somebody else to represent you at trial?
He doesn't want to work for me.
Is that yes?
I guess so.
Okay.
I'm not aware.
But I mean, how many times have y'all spoken to each other? And
We smoked maybe 3 times. He doesn't want to really communicate with me at all.
all right. Then I'm going to find good cause to release him. The next person on the trial docket will be appointed to represent you. Set this for trial. And see where that is. We try to get it as soon as possible. Okay. Anything else?
This is where things really heat up. The defendant, Zane Bureau, isn't fighting the charges, he's fighting his own defense counsel. That's a rare and risky move in open court. When a defendant accuses their court-appointed attorney of neglect, the judge has to decide if the relationship is too broken to continue. And here, the judge actually sides with Zane, releasing his lawyer and appointing someone new. But let's not miss the irony just moments later. Zane asks about getting bond reinstated. Right after testing positive for drugs in jail, think about that. You're in custody, no access to substances, yet the tests keep showing THC. Something doesn't add up. Do you think he's telling the truth, or is this just another stall tactic?
That is all. Thank you.
I can ask a question with you. I can ask a question.
Go ahead.
So there's no way to get bond reinstated or any of that?
Not while you keep testing positive for drugs.
Is there anywhere I can be drug tested?
Yeah. Well, we've been testing you regularly, and you keep testing positive for THC, tetrahydrocannabinol. I don't know how that's happening in the jail.
No,
And you're getting
tested
marijuana,
in
but you're testing positive. But that's the problem because each of positive test is a crime. You're illegally possessing drugs. That weighs against you on getting a bond. If you keep
I apologize.
yeah, when you want to stop interrupting me, we'll bring you back out and we can talk. But every time you interrupt, you ruin your communication with me, sir. All right, so Mr. Buren is set for trial. And Sam Hodges.
brought that up.
I need 25 CR791 is now called Thomas. Is it Foy Wayne Smith?
Yes, sir.
That's a good long name. You were here with your attorney, Mr. Deucer, and the state's attorney does. The defendant will to a formal reading of this indictment. An arraignment, can we proceed in summary?
Yes, sir.
In summary, this indictment alleges, sir, that on or about April 29th, 2025, in Jefferson County, Texas, you committed a third-degree felony of unlawfully possessing a firearm by being a previous convicted felon, as you were convicted in November of 2020 in Orange County, the district court there, for robbery. This is a third-degree felony that carries with it, if convicted, no less than 2 nor more than 20 years, no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range for a third-degree felony such as this?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 5 years in prison. Is that your understanding?
Yes, sir.
If
I wanted to hire a lawyer, so I didn't know he was going to be here.
Who's he?
Right?
What about it?
I was going to hire him. I didn't know he was going to be here. He showed up. So,
Well, he's your appointed lawyer. Have you hired him yet?
no, sir.
Well, he's still your lawyer until. What are we going to do today?
We're going forward today.
Like,
I'm following the agreement that y'all reached,
Yeah.
but
All right.
what do you want to do? So,
I guess we'll go with it.
is that your final answer? Yes?
Yes.
Okay. All right. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, sir? Guilty or not guilty?
Yep.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I'm going to show you.
Now, the focus shifts to Thomas Foy Wayne Smith, charged with unlawful possession of a firearm by a convicted felon. This might sound straightforward, but it's one of the most serious repeat offenses in Texas law. The twist? Smith wants to hire his own attorney mid-hearing, except the person he wants is already his appointed lawyer. It's confusion meets courtroom reality. The judge, staying calm, reaffirms the plea deal. 5 years in prison. Notice how methodically the judge walks him through every right being waived. No jury, no appeal, full acknowledgement of guilt. It's almost procedural. But behind that calm is a system designed to ensure defendants can't later claim they didn't understand what was happening. Would you say this plea sounds genuine or just resignation to fate?
It's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence, without objection admitted. Among other things, the states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The document's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with your attorney according to this, so help you God. Correct?
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is
Yes, sir.
I shall follow this agreement, sir. If nothing further, I will find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by previously being a convicted felon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes.
Anything else?
No, sir.
Two defendants, two very different stories, but both ending in the same place, prison time. Zane Bureau's courtroom clash shows how tension between client and counsel can derail a defense before it even begins. And Thomas Foy Wayne Smith's plea demonstrates how repeat offenses carry heavy, unavoidable consequences. These moments capture the stark contrast between frustration and finality, where emotion meets the cold structure of the law. So, what's your take? Were these rulings fair? Could either man have changed his fate? Drop your thoughts in the comments below if you found this breakdown as intense as we did. Don't forget to like, share, and subscribe for more jaw-dropping courtroom analyses every week.